Hello everyone, my name is Frank Angileri and I'm here with Mark Lorelli, and we'd like to welcome everyone to our webinar where we're going to try to look at some second court or Supreme Court and Federal Circuit or District Court cases that are, in our view, somewhat impactful and what impact they might have going forward. If you have questions, you can type them into the chat box and we will try to answer them at the end of the webinar. Also, after we complete this, there'll be an opportunity to download the slides from the Brooks Cushman website so that you can watch them after the fact, or you can also listen to this in a podcast form the same way. You can download that as well. So again, my name is Frank Angileri. I've been practicing for about 25 years, and my partner Mark Lorelli with me has been practicing for close to 20. We tend to focus on the litigation side of the practice, and today we've got four main topics that we're going to try to touch on. The first deals with the two famous Supreme Court cases on inter-parties review, Oil States and SAS. Then we're going to talk about pleading standards and how there used to be a forum pleading, and that's been evolving, and we'll try to give you an update on that. We'll talk about patent damages, remedies, and finally, update on venue in view of the changes last year in venue. So I will start with the Supreme Court and inter-parties review. And these two cases, Oil States and SAS or SAS, are somewhat famous and I think fascinating for the way they kind of came together. And if you look at the nature of the opinions, it seems as though the whole package was somewhat difficult for the court. And there's also some indications from the dissents in terms of how they seem to think these things might point to the future. We're going to talk about three Supreme Court cases today, and what's interesting in all of them is they all have a dissent where at least two justices joined. So what's fascinating about that is, in some respects, many of the patent cases that the Supreme Court has taken in the past 15 years or so have been close to unanimous, and all three of these reflect some tension. And I believe one of the reasons that might be the case is that they cross over into non-patent issues, and we'll try to touch on that. But Oil States was the most famous before it came out, and because it threatened to essentially obliterate the whole post-grant procedure process that came from the AIA now 7 years ago. Of course, it was a 7-2 decision, and they did not blow up the system, but I think in some respects the SAS case is a reflection of the tension there. So there were multiple challenges, constitutional challenges, one separation of powers, one Seventh Amendment. They rejected both, and principally it was because they held that patents are public rights. And it's along the lines of, if the government giveth, the government can take it away. When you grant it, it's a public right, so you can take it away. The government can do it without an Article III court. And the last bullet point, the fact that they used some kind of court-like procedures was not considered dispositive. What is interesting about this is you have a dissent from two justices who are traditionally somewhat conservative, Gorsuch and Roberts. And so they seem to be, I guess, nervous. That's probably a bad word, but they were concerned about a court taking away this right, property right, or rather a non-court, PTAB. And then you have a concurrence from traditionally more liberal voting justices, Breyer, Ginsburg, and Sotomayor, who made a point of saying, hey, I know this case turned on the public-private right distinction, but there may be other cases where even though it's a private right, it still doesn't have to be an Article III court. So this case is interesting because it really pushes outside of patent law into more general Supreme Court type principles. The next case, SAS, in a sense, does the same thing. And the big underlying issue here, I think, so the specific issue was whether the PTAB has to basically decide everything that's put in the petition, and the court said that the PTAB must address every claim that's challenged by the petitioner. The PTAB has interpreted this to say they have to decide every ground, and maybe that's because they don't want to have this issue up again. So the net impact of this case is that PTAB petitions are going to be more of an all or nothing thing. But this again bridges over to general kind of legal principles. And the underlying issue here, which is the third bullet point, was this question of Chevron deference and whether the court was going to give deference to the agency's rules. Now, what's interesting about the dissent in this case is the four traditionally liberal voting justices, Breyer, Ginsburg, Sotomayor, and Kagan, who dissented. And if you follow the recent appointment, Judge Kavanaugh, apparently one of his big issues is the whole idea of Chevron deference, and apparently I'm not a huge fan. So this again is I think this case extends beyond just patent issues and into these broader questions of Supreme Court jurisprudence. But let's talk about it from the patent side of things only. I think the first and biggest impact is that the PTAB is going to try to give more attention to issues that might be perceived as due process issues, because if you look at SAS and oil states in tandem, one sense you might get is that the Supreme Court was nervous about or concerned about the whole process, whether it was legitimate or not, but they didn't want to blow up the system, so they wrote these two opinions which in tandem keep the process alive, but it suggests that the PTAB needs to kind of dot the I's and cross the T's and be very concerned about due process type issues. We've got 3 bullet points there: motions to amend, expanded panels, replies, and reply evidence. Those are 3 areas where there have been some criticisms raised of what the PTAB does, whether motions to amend are fair and proper. Replies and reply evidence, there's a question there about when a petitioner adds evidence in a reply and the patent owner doesn't have a chance to respond, is that fair? Federal Circuit Bench Bar Conference recently, the PTAB's Chief Judge Ruski was commenting about the fact that they're looking at new rules on replies and reply evidence, and so they appear to be aware of that. Further down, there may be less reliance on so-called precedential decisions, although they just did identify some as informative recently. We may see more formal rulemaking, again, in an effort to avoid any kind of future challenges. On the ground sort of impacts, getting past the kind of higher level nuances, where do we end up with this SAS case? And I think the biggest factor is going to be at the PTAB, because these decisions now have to be, in some respects, all or nothing. We may see some discretionary denials where if there may be 1 or 2 claims that they think should be instituted but the rest not, they have to make a decision. Do you institute on the whole thing, even though the final written decision ultimately might only impact a few claims, or do you just deny it as a matter of discretion, which they have the right to do? Or could you have some one-claim institution decisions where they institute on only a few claims, which frankly would not be very good for the petitioner, because you end up with claims that survive the IPR, and that those would make, that to jump to the third point in this outline, from patent owner's perspective, those would be very strong claims. We've got bulletproof in quotes just to kind of shorthand for that idea. From the petitioner's perspective, you have to confront the fact that there's going to be broader estoppel in practice. The way the Federal Circuit's case law evolved in the past couple of years, there was a situation where a petitioner could file a petition for an IPR on multiple grounds, and grounds that were denied at institution would not have estoppel effect. That is likely no longer going to be the case, so it's more of if a petitioner is filing a petition, you have to be prepared to take the estoppel, good or bad, including the claims where you lose. Jumping down to the district courts, because of this broader estoppel, it may be the case that stays are granted more freely, and then it may perhaps lead to more post-IPR settlement if, again, you've got binding decisions both ways, both affirming patentability or canceling claims. And then the last bullet points, the Federal Circuit, they may take the Supreme Court's hint and be less deferential to USPTO on rulemaking, and we may get some cases out of the Supreme Court in general, not necessarily patent cases that deal with that issue, the so-called Chevron issue, and then it remains to be seen whether the Federal Circuit will remand pending cases for non-instituted grounds. So that's the IPR update, and I'm going to now turn it over to Mark to talk about the new pleading requirements.
Good afternoon, this is Mark Lorelli, and I've got pleading infringement section of this update. When we were thinking about topics for this webinar, this pleading doesn't really have the same interest that SAS and oil states does, but the reason why this made the list is it kind of gives a good summary of the last 10 years, if you will, of pleading patent infringement. And I say 10 years because we go back to Iqbal Twombly by the Supreme Court, which was over a decade ago, and although it wasn't talking about patent cases, it talked about the requirements for pleading. And if anybody knows complaints from over a decade ago, for patent complaints especially, you'd have maybe one page. Here's a patent, here's the defendant makes a certain product and it infringes the patent, and that was enough, and that passed muster. After the Supreme Court cases of Iqbal and Twombly, there was a plausibility requirement requiring more facts be alleged in order to meet that standard. Well, in patent law, though, it kind of became a little bit more difficult because there was always this Federal Rule of Civil Procedure form out there, Form 18, that provided that 3-paragraph sample for pleading direct infringement. So what we had was a lot of district courts that wanted to apply the more stringent standard of the Supreme Court, and other district courts that were saying, well, it's a form, as long as they comply, well, as long as the plaintiff complies with the form, they're fine. The Federal Circuit stepped in after quite a bit of wrangling in district courts, and of course this wrangling starts at the pleading stages, so it slows down a lot of cases from getting going. But the Federal Circuit stepped in and said, in the in re bill of lading case, and said, okay, Form 18, it's still there, it's still good, if that's how that satisfies the standards for pleadings. So basically, as time progressed, as noted here, the Supreme Court got rid of Form 18, and that was more recent. And basically what everybody assumed from that is that because Form 18 is now gone, the standard for pleading patent infringement is much, much higher. Much more facts have got to be presented in a complaint. This is an interesting case, a disc disease, because of the timing of it. It was filed one day after Form 18 went bye-bye. And the district court granted a motion to dismiss because of the fact that the patent owner primarily relied on Form 18 for that very simple complaint. The patent owner attempted to amend, the district court wouldn't let them, and the patent owner had to appeal this issue, which is not all that common, but appeals this issue. It's not common because typically what might happen is a patent owner might go back and amend their complaint and add those details, because it's typically not that hard to do if it's a legitimate complaint that's being brought. But the Federal Circuit did something interesting in this case, which I think kind of brings us full circle for that decade, is the Federal Circuit reversed the dismissal and held that this complaint satisfied the pleading standard whether Form 18 was in play or not, because it met Iqbal Twombly. And that was interesting because it was a very much a Form 18 complaint. And how the Federal Circuit justified it was really in one sentence. It said, this case involves a simple technology. So therefore, at least this panel of the Federal Circuit felt that where there's simple technology, the type of bare bones pleading of Form 18 is satisfactory. Perhaps it might not come to the same decision if the complaint was if the patent was much more technically involved. But we were talking about a spinal implant here, so it's not that it was excessively simple, but it was simple enough for the Federal Circuit to make this statement. And it made this statement is interesting in kind of understanding where the Federal Circuit sees Iqbal Twombly affecting patent pleadings. There was a footnote in this case, which was another reason why it was interesting and why it helped bring these 10 years of cases full circle. The Federal Circuit has never really recognized a distinction between Form 18 and the plausibility standards of the Supreme Court. So basically we know that for simple cases, Form 18 is good enough, and we know that probably for some more difficult cases, the Federal Circuit might require more facts pled to bring that plausibility standard more in line with what has been expected from the bar, I think, in these years leading up to Form 18 passing away. But what is interesting here is that there's two cases, lifetime, and then of course this disc disease. So what we know from these two recent Federal Circuit cases is that the pleading standard is not as high as many believed or assumed that it would be when Form 18 was gone, but it's at least Form 18 for simple cases and probably something a little bit greater as you get into more technologically complex complaints and patents. Really what I think the impact of these types of cases are, we'll still see the same detailed complaints where there are competent claims of patent infringement being brought against, between competitors and folks that practice the inventions. Perhaps we might see a regression to Form 18 simplicity for complaints that are designed to sue a lot of people for the same complaint, or for complaints that are not as fully thought out. And we'll kind of see how those end up going before the Federal Circuit. But at the end of the day, there's not going to be a great change in, I think, how patent infringement cases are pled. But at least this case, or these two cases from the Federal Circuit, gives the opportunity for Form 18 pleaded complaints to proceed. So that's why it's interesting, and that's why it was included by us in this webinar. And I'll turn it back over to Frank to go into patent infringement damages and remedies.
Thanks, Mark. Okay, so the first damage/remedies case is another Supreme Court case. And kind of continuing on the theme today, it's a patent case, but it bridges into non-patent issues. and it also has an interesting dissent. The specific case dealt with extraterritorial damages. You had infringement under 271F2, which relates to manufacturing components in the U.S., but then the actual ultimate infringement doesn't occur until you're overseas. And what was interesting in this case is that the plaintiff received lost profits for lost profit damages for contracts that would have been overseas contracts, but they successfully argued at trial that but for the U.S. piece, the manufacturing the components in the U.S., the domestic infringement actions, they would have made those overseas sales, and so therefore they were entitled to them as lost profits. They won the lost profits for extraterritorial damages at the district court. The Federal Circuit reversed, citing their existing cases, and then it went to the Supreme Court. And the Supreme Court reversed the Federal Circuit. And so they held that the plaintiff could get those extraterritorial damages. A number of interesting things about it. First, it's a 7-2 decision, so again we have a dissent, which historically has not been terribly common in patent cases, or at least not as common as other cases. Second, the dissent is two justices who historically would not be expected to vote together. That's Justice Gorsuch and Justice Breyer. But the issue is this extraterritoriality. And that the third thing that makes it interesting is that is, again, in some respects, a non-patent issue. It's an issue that comes up in other cases. So you got 3 Supreme Court cases that are looking at patent issues that kind of bridge over to other non-patent issues. In terms of the analytics, the Supreme Court has a 2-part test, which is on the slide now. Does the text of the statute provide a clear indication of an extraterritorial application, or does the case involve a domestic application of the statute? The Supreme Court jumped to point 2 because they said if we can decide on point 2, we don't need to address the broader question. And so they said that because these damages, the patent infringement here has a domestic impact, namely manufacturing of components in the U.S., then it can be regulated. And that's the first bullet point on this slide. A couple of interesting things about the case. It is, in a sense, a pro-patent case in the context of a fairly longer-term trend where the majority of the decisions out of the Supreme Court relating to patent cases have been maybe not so great for the patent owner. The Supreme Court cited general damages propositions that are somewhat open-ended about the fact that damages entitled to fully compensate the patent owner for infringement. And then, of course, it applies damages extraterritorially, which is, at the very least, not common. You can clearly see in the dissent a strong hesitation toward any kind of extraterritorial application of our law for fear that it'll be applied reciprocally by other countries against us. Some of the things that they did not decide is the standard, for example, causation, governing when you can actually get these damages, nor whether extraterritorial damages are available for other subsections or for reasonable royalty. And it would seem harder for the other subsections where the infringement focuses in the U.S. and the sales are in the U.S. So it's hard to say where this will go, but at least at this point the Supreme Court was expressing what it was not deciding. The second, it's a damages case, but it's not a damages case, and this one is another generally applicable case that's very interesting. Gilead Sciences versus Merck. This is a Federal Circuit case that affirmed a judge's decision to essentially void a $200 million damages verdict based on unclean hands. As you can see from the bullet point, Gilead filed a DJ and Merck counterclaim, so Merck is the actual patent owner. There was a claim construction that led Gilead to stipulate to patent infringement, so the trial focused on invalidity, and the jury ruled for Merck and awarded $200 million in damages. After that, the district court held a bench trial on Gilead's equitable defenses, and one of those was unclean hands. And this is not inequitable conduct where you're talking about misconduct in the patent office. It's the more generic defense of unclean hands that, frankly, we don't see very often in patent cases. The conduct that was unclean was essentially, to put it in its simplest terms, the violation of what we would come to know as a prosecution bar. It wasn't technically a prosecution bar in litigation, but there was a transaction involving Merck and an entity where there was some due diligence type exchanges. That entity was later acquired by Gilead, so that's how they sort of got tied how the misconduct was tied to the parties of this case. There was an agreement where there was a so-called firewall, where in the context of this due diligence, the people who participated in these meetings could not also participate in patent prosecution. That's why I call it a prosecution bar. They didn't, those are my words, but it just helps understand the scenario. And the bottom line is there was a Merck scientist who participated in this meeting even though the rules were that anybody in the meeting couldn't participate in prosecution. That scientist then participated in prosecution. The scientist actually narrowed the claims of a Merck patent application to focus on a compound that was disclosed during this firewall meeting. That obviously made it easier to expedite the prosecution by narrowing the claims. They ultimately enforced that narrowed patent against the lead. In the context of the trial, the Merck scientist also gave false testimony as a witness and during discovery and at trial about this conduct. And ultimately, the district court held that because this scientist had used that confidential information to facilitate the prosecution and then testified untruthfully about it at trial, that constituted unclean hands, and that conduct was directly tied to the cause of action. In other words, it wasn't just sort of bad acts in general. The sense of it is you use this information to get the patent, and you use the patent against the lead, and then you testify untruthfully about it at trial. So all those facts were very connected to the cause of action, which seemed to be important to both the district court and the Federal Circuit in finding unclean hands. The last bullet point, it just emphasized that there was no inequitable conduct. It wasn't about sort of being untruthful to the patent office. It was about being untruthful to the party and to the judicial process in court. These bullet points address the concerns that Merck said, which is that you can't vacate a damages verdict based on so-called unclean hands or just wrongful conduct. And I think the thought there's issues at trial all the time and evidence and so forth, and you can't just vacate the entire jury verdict, essentially, or negate it, rather. Likewise, there was a concern that unclean hands is equitable, but it's being used to negate a damages verdict, which is not equitable but legal. And in any event, as these quotes indicated, unclean hands closes the door of a court of equity and so forth. However improper it may have been the behavior of the defendant, requires that the claimants have acted fairly without fraud or deceit as to the controversy and issue. The Federal Circuit held in the next slide that the unclean hands gives wide range to the equity court's use of discretion in refusing to aid the unclean litigant. The unclean conduct was related to the equity of giving Merck the relief of patent enforcement. So the bottom line is, at the end of the day, the court said that, and this is an appeal court, so it's basically just affirming the district court's findings. It said that the district court was not clearly erroneous in finding that you had this unclean conduct that was directly tied to the cause of action. The case is interesting because it's not common and because it's really an open question for how broadly this doctrine can be applied, because every litigation is going to have allegations of witnesses not testifying truthfully, and I'm not suggesting that it's by any means acceptable, but it seems like the kind of allegation that could come up a lot. And the Federal Circuit seemed to be, in affirming it, it was focused on the fact this conduct was found to be extreme and was found to be very closely tied to the cause of action, and therefore it was proper to enforce this doctrine in this case. It would seem that we are going to see these kinds of defenses and or counterclaims crop up perhaps more in the future than they have in the past. That's our summary on the damages and remedies. And now we'll talk about the latest and greatest on venue law. Mark.
Yeah, so it's the latest and greatest on venue. Pretty much venue has now been fairly well decided. But, about 18 months ago, T.C. Heartland from the Supreme Court really kind of changed things around on patent cases. And in that 18 months, it changed a lot of things around on waiver and when you could raise a venue defense, because typically if it's not pled, it's waived. If it's not pled in the first response of pleading, it's waived. So there was a lot of waiver issues. There was a lot of issues involving cases that were already pending. What I try to do here is conclude the venue law as it would stand with a newly filed case, so that if a venue objection is raised, it would have to be in the first response of pleading. And that's been happening now, but as the Federal Circuit is deciding certain issues, it's becoming much more clear as to how T.C. Heartland ultimately affects patent litigation. Although not this year, last year, the Federal Circuit started its work explaining kind of the details of T.C. Heartland. In this slide here, T.C. Heartland, as I'm sure everybody knows now, it was a holding with regards to where a defendant resides. And the statute allows venue in two places: where the defendant resides or where a defendant has committed acts of infringement and has a regular and established place of business. And in 2017, the Federal Circuit handled that second bullet point. There was a case that came up on mandamus from the Eastern District of Texas where Judge Gilstrap announced a 4-point test for that regular and established place of business. The Federal Circuit in Ray Clay provided its own three-point test about that requirement, and basically that it had to be a physical place. It had to perform regular and established work. It had to be uniform, methodical. It had to be a real place of business, and that the third point was that it had to be a place of the defendant. You couldn't find an employee that lived in a certain district and make that work. So that was the first one of the cases that came up on mandamus to the Federal Circuit. And kind of like how the forum nonconvenience law got revised in patent jurisprudence, it started with writs mandamus. A case that Brooks Cushman handled was the first one in that regard, but now it's the same thing is happening on venue. And the first one was at In Re Cray that handled the second bullet point. But now today, though, I'd like to talk about that first bullet point because that's really what's been identified more fully by the Federal Circuit in the months of 2018. And we know from T.C. Heartland that a domestic corporation resides only in its state of incorporation for purposes of the patent venue statute. That was what T.C. Heartland was about. But let's go to the next slide, which is the first case that the Federal Circuit handled on mandamus from the Eastern District of Texas, and this was In Re Big Commerce. And here it was the defendant was a Texas corporation, but it was based in a different district, Austin, which is the Western District of Texas, not the Eastern District of Texas where this patent owner brought the case. And the Eastern District of Texas found that, well, if you're headquartered in Texas, that's good enough for a proper venue in East Texas. The Federal Circuit reversed that and basically said, if your principal place of business is in a certain state, venue is proper only in the judicial district where that principal place of business is. So it would be the Western District of Texas for Big Commerce in this case. So those companies that have principal places of business in Dallas proper and not the eastern suburbs of Dallas or in Austin or in San Antonio, they're not going to be subject to venue in East Texas for at least that reason. There obviously could be other factors that subjects them to venue in East Texas. The next case was also on mandamus from the Eastern District of Texas. Again, it was on a failure of the Eastern District of Texas to dismiss. And this was ZTE. And the Eastern District of Texas court ruled that the defendant failed to prove that it did not have a regular and established place of business in the Eastern District of Texas. This was the decision from the Eastern District of Texas, so it did not dismiss the case. Mandamus was filed with the Federal Circuit. The Federal Circuit picked it up and explained that it should be the plaintiff or the patent owner that has the burden of establishing venue, as opposed to the defendant having the burden to prove that it did not have venue. So that was it's a burden of proof issue, but it came out really in the defendant's favor. But as you would expect, the plaintiff would bear the burden of establishing what it is pleading in the complaint with regards to venue. The third case that came out in 2018 with regards to venue was HTC Corp. And this one was on mandamus from the District of Delaware. It's a little bit more interesting case because there were two defendants that were involved, but two related companies, HTC Corp., which is a Taiwanese corporation, and HTC America, which is a Washington corporation. So HTC America certainly is subject to venue in Washington, and wherever it commits acts of infringement, it has an irregular and established place of business. Presumably that was not Delaware. The district court noted that venue was improper for HTC America, and the plaintiff dismissed HTC America without prejudice. But the district court retained jurisdiction over HTC. Mandamus was filed, and in this instance, the Federal Circuit denied that writ of mandamus because it applied the alien venue rule to HTC Corp., the Taiwanese corporation. And basically, it applied the long-standing rule that aliens that wholly operate outside the federal venue laws are subject to venue anywhere. And that's important when we start talking about venue of a lot of companies that don't have a presence in the United States. And the Federal Circuit also did note that Congress did not change this well-established alien venue rule when it amended 1400B, which was at issue in T.C. Heartland. So basically what we have here is a bunch of Federal Circuit cases on mandamus that helps spell out the first prong of that T.C. Heartland decision, where a defendant resides. And it's fairly well developed now from Federal Circuit law, so patent owners can be more informed when they choose a jurisdiction to file their complaint. That takes us to the end of our plan presentation, and we're going to go and see if we have questions here to respond to.
We have two questions. The first one, Mark, is for you. It says, how have the pleading and venue law changes impacted the approach to filing complaints?
I think pleading changes haven't changed the impact that much. It requires a patent owner to put more thought into their complaints, which is a good thing, but it's a plausibility requirement. So if you have a claim for patent infringement, meeting the plausibility requirements in a complaint are not that onerous. So that hasn't changed too much. Now with the Federal Circuit enunciating that Form 18 may be sufficient, may be seeing some complaints where people might not want to put that time in on the front end. You might start seeing some of that, so we'll see how that works out. But I don't think it's going to have a big impact. On venue, T.C. Heartland certainly had a huge impact on venue. And as you see from these cases on mandamus, certain patent owners are trying to test the limits of that T.C. Heartland decision and figure out when they can get into certain venues. T.C. Heartland has changed the landscape dramatically as far as where a patent owner can file suit, and a lot more thought has to be put into that decision. A lot more research is typically done on the front end to find locations of a potential defendant so that you can know all the venues where that person would be subject to jurisdiction so that you can make the informed decision as to where you might want to bring a suit. I think that's the real impact, is investigating where somebody is subject to venue and then selecting the most desirable venue for that particular case, as opposed to the way the law was before, just selecting the most appropriate venue if you had a defendant that was selling nationwide. Frank, do you want to go with that second question here?
Yeah, I will.
And also, though, if there are any other questions, we can still take those at this time if you want to type them into the chat box.
The second question asks, what is the Supreme Court taking next, or are they going to keep taking patent cases? It seems they will keep taking patent cases just because they have been taking patent cases. They've got a very clear track record now of being very interested. As I mentioned, these three cases today are all have something in common in that they bridge over to non-patent issues. But the Oil States case famously states, "We emphasize the narrowness of our holding," and that's a quote. And that to me, that really speaks volumes. And that, in combination with the SAS concerns about procedure and whatnot, I think, and also the AIA itself, the whole statute is ripe for further review, because those cases are just starting to kind of bubble through the system. So it seems as though the AIA will continue to generate issues for review that might ultimately make their way to the Supreme Court. And the other issue that the Supreme Court hasn't really gotten a lot into, but the Federal Circuit has, is damages. This case that we talked about today is a damages case. There was a Microsoft case on damages, but some of the things like apportionment, the Federal Circuit has been very active in. The Supreme Court has not necessarily weighed in just yet. So we do not have any more questions, so that concludes our presentation. Of course, the subject matter that Mark and I discussed today is for informational and academic purposes. It doesn't reflect the view of any of our clients. But we thank you very much for listening to the webinar today. As I mentioned, it'll be made available for download at our firm's Media Center. And if anyone has any questions, they can contact Mark or me anytime. And again, thank you for listening, and we look forward to hosting another webinar soon.
Thank you.